Welcome to the July 20th, 2026 Zoning Board of Appeals meeting. Tonight, where we had a couple new members directly on the board that didn't come in as alternates, we decided to have an orientation meeting, we'll be going through the legal parts of this board. So everybody kind of has a fair understanding of what's going on. With that, I'm going to turn it over to Carolyn, who's now has control of the meeting.
All right, take two. So for the record, I'm Carolyn Murray from KP Law. I'm joined tonight by Haley Reifus, and we're going to split up this training for you all. And even though as the chair said at the top that this training is in part due to the fact that there's some new board members, even some more seasoned board members are going to learn a thing or two tonight, because the legislature has been very busy in the last couple of weeks. When the budget was passed and signed into law by the governor on July 9th, it included some outside sections that amend Chapter 40A. So we're going to highlight some of that for you this evening. There are also there's this economic development bill that is currently pending with the legislature that has a number of proposals that it feels somewhat like rapid fire from the legislature lately, in the sense that every other day we seem to get a new draft of a bill and we're asked, can you please comment on it in the next hour or so, trying to give the municipal perspective on these things. So that's a quick way of saying more is coming. And as you'll start to see tonight, it's got a heavy emphasis on housing, as it has been having for the last couple of years. So we will cover what we can. And like I said, there might even be a further update, say in another week or two, on this economic development bill. So as we start, as we always do, with a disclaimer that when I do trainings like this, I always invite folks to ask questions as they come up. I know sometimes that can kind of ruin the rhythm a little bit, but I also find that if you wait till the very end, you've lost interest, or you've forgotten what it was that you wanted to ask about, or you've lost the context. So feel free to interrupt at any time. I will, despite Mr. Connor's comment that this is a long presentation, I will try very hard to keep this moving and to get you out of here at a reasonable hour. But you might have questions, and you're certainly happy to ask questions on a hypothetical. We're not really here to bring up something that happened last week, last month, or that might be on the board's agenda for next week and discuss how perhaps we should apply it. So without further ado, we'll jump into this and let you know what we're going to cover tonight. So as the title said, we're going to cover the roles and responsibilities of the zoning board. That's going to include a little bit of an introduction to the Zoning Act, which is Mass General Law, Chapter 40A. We're also going to include, where it's relevant, the sections from your own zoning bylaw, so that you can see that in some instances, the bylaw might be consistent with Chapter 40A. In some instances, it might not be. And in some instances, it might actually be inconsistent. We'll talk about that as we go along. We'll talk about special permits, variances, my all-time favorite, pre-existing non-conforming uses and structures. We'll go through the appeals process, enforcement, and we'll also talk a little bit about some of the state limitations on what we can and cannot do via zoning, touching upon the Dover Amendment. And then we will also cover a little bit, because everything you do as a board member impacts the open meeting law, it impacts the public records law, and obviously the conflict of interest statute. We're going to cover the more pertinent portions of those sections for you. And I will say to you that I could probably point to a number of items on this list that we would do a standalone training for. So we're going to try and cover an awful lot of ground in a relatively short period of time. I want everyone to understand it is really just meant to be sort of an overview. If there's anything in particular that you want a deeper dive on, we're happy to either share some other training materials with you or come back at a later date if you think that would be of any value. And then we will do questions and answers at the end, but as I said, I welcome any questions as we go along. So just starting at the very beginning as a board and what every board member should know. First and foremost, you should know what your authority is. What is your scope? What is your role? What are the standards before you come into any particular meeting? If you haven't gotten into this habit yet, what's on your agenda? Is it a variance? Is it a special permit? Is it a non-conforming structure? What is the standard that you need to apply to each one? And kind of getting all of that straight in your head before you come into a hearing. What's the quantum of vote that applies to each decision? What is the applicable state law versus what are the applicable versions of your local bylaw that might be relevant to help you make those decisions? And also understanding a little bit the authority of other boards. Sometimes it's helpful, as you see when it comes up in the public hearing context, folks will start talking about things, say perhaps pertaining to wetlands. And it's always helpful to be able to say, that's a matter for the Conservation Commission so that you can help focus the discussion and keep everybody really helping them to stay in their lane with respect to the application that's pending before you. So we'll start with Chapter 40A, which is the Zoning Act. And this is the state legislation that basically gives towns the authority to enact zoning laws. So this is providing sort of a high-level framework for us. This is where we get the authority to adopt zoning bylaws and ordinances. It helps us understand some of the standard rules that are going to apply across the state, whether you are in Plymouth or you're in Plimpton or you're out North Adams. It's going to be the same process throughout the state for adopting zoning bylaws or amending them. And what are the objectives of Chapter 40A? The idea behind the zoning bylaws is essentially supposed to be, it's a safety provision. Sometimes it's called a town's police powers, but it really is about how do you develop a town in such a way that you make sure that it's still safe in terms of police, fire, and floods, keeping buildings appropriately separated from each other, keeping roads of a sufficient width for emergency vehicles to come through, thinking about how certain uses may or may not be compatible if they are immediately adjacent to one another. So that's sort of the broader context of what Chapter 48 provides. As we go into our own local bylaw, then what do we do with Chapter 48? Well, the first thing we do is we adopt zoning bylaws as to how we're going to regulate land and how it may be used. So through zoning bylaws, you divide the town up into zoning districts, and you decide what sorts of uses are permitted within those zoning districts. So the typical ones are residential, business, commercial, industrial, but they can have a myriad of names, and they typically do. You can also have overlay districts, where in addition to the underlying zoning, which might be, let's say, a business district, you might have an overlay district for, say, a town center, so that the underlying requirements of the zoning district apply, but then there's an additional layer on top of it that might be more specific to maybe just a subset or a sub-district of that zoning district. One of the things you have to bear in mind for zoning is that every zoning district, we're supposed to be uniform with respect to the structures or the uses permitted. So if we're going to say, for example, that banks are allowed in business districts, we have to make sure that they are allowed in all of the business districts. So if we have some sub-districts, we need to make some sort of distinctions there as to why a certain use might not be allowed in a sub-district. And we have to make sure that, for example, with single-family houses in a residential district, if a single-family use is allowed, and we then decide, but but we're going to establish a particular lot size. That lot size is going to apply to every single lot in that zoning district. We can't suddenly say, except for in this one particular area of town where we're going to require a larger than typical residential lot size, for example. So we decide what uses can go where, and then we decide how the uses are allowed. And typically they're either allowed by right, meaning they don't have to go to a zoning board, they don't have to go to a planning board for any kind of special permission. They can go straight to the building inspector and they can get a building permit. So the most fundamental of those would be getting a building permit for a single-family house in a residential zoning district. Some uses might also be subject to site plan review. Site plan review typically is something that allows a broader review of a project that is still allowed by right and does allow for maybe some input by the town to shape what the project would look like, or perhaps to make some conditions, but essentially the use is still allowed by right. Uses that are allowed by special permit, meaning you're going to have to go through a special permit process through whoever is designated as a special permit granting authority, whether it's the zoning board, the planning board, select board, whatever the bylaw provides. And you're going to apply the criteria that your specific bylaw establishes for those special permits. And then there's the possibility of a use variance. I'm not going to spend a lot of time on that because currently your bylaw does not provide one, so we don't need to worry about it, but I will at least explain what it means. So we'll start with adopting and amending zoning bylaws. So you've probably have experienced this at town meeting where a zoning bylaw begins with, it has to be initiated by someone, could be the select board, could be the planning board, could be a property owner, could be a citizen petition. It then gets referred to the planning board for a public hearing and they make a recommendation to town meeting. Town meeting has to vote to approve that zoning bylaw, and then it is ultimately sent off to the Attorney General's office for approval as well. When you adopt a zoning bylaw, it often has the unintended or perhaps intended consequence of rendering structures and uses non-conforming. And I'm going to talk about that a little bit more later, but just to sort of give you the sense of what does that terminology means. It means, for example, if we adopted a zoning bylaw to increase a minimum lot size, let's say you had a $20,000 square foot minimum lot size in a district, and you decided, you know what, that's really too small. We want to go up to a 30,000 square foot lot size. Well, what you've essentially done by increasing that lot size is now every 20,000 square foot lot is now rendered non-conforming under your zoning bylaw. It could also apply to uses. For example, lots of times you see in communities that maybe zoning was a little bit slow to get adopted and the town grew up with certain businesses in certain places, and then over time those businesses became zoned for, so they were no longer allowed in that particular district. Let's say we've decided this is where we think single-family homes should go, so we don't want, for example, a gas station to be located in our residential zoning areas. That doesn't mean an existing gas station has to go. It means the existing gas station is simply rendered non-conforming, and it's going to be a little bit of a different process as to how that gas station makes changes going forward. So I've talked a little bit about zoning districts in the general sense. Here in Plymouth, you've got 17 zoning districts. All of your zoning districts should be found on the official zoning map. And there's a list there of a few different types of your zoning districts. If there's any sort of uncertainty, folks usually go to the zoning map first, but sometimes the zoning map can be a little bit ambiguous as to whether a cross-hatching has crossed over to the east or west side of a line. The rules for interpreting where the district boundary is to be interpreted is found in section 204-3 of your local bylaw. So I talked a little bit earlier about an overlay district. It's superimposed over an underlying zoning district. So all of the rules that apply to the underlying district are still in play, but then sometimes there's a reason for an overlay. Maybe we're going to identify just a certain area of town where within a business district, we're also going to allow perhaps just certain types of businesses, or maybe a certain relaxation of some of the business district requirements. Aquifer protection and floodplain are two pretty typical overlays that, based on where your water supply happens to be, or if it's an area that might be prone to flooding, and you are a coastal community, so there will be those. There's like an added layer of protection that goes on top of that, so that maybe there are some additional requirements as to how you can develop property located in those overlay districts. So turning now to how you administer zoning. First and foremost, it's going to go through your building commissioner. He is your first line of defense and your zoning enforcement officer. But right after your zoning enforcement officer, building commissioner, this is the board you are all sitting on, the Zoning Board of Appeals, with your 5 permanent members and your 2 associate members. As you know, you're appointed to 3-year terms. Associate members can only act when a permanent member is unable to. And what does that mean? Maybe a permanent member has a conflict of interest. Maybe someone, is on a fabulous vacation, is going to miss a hearing, or perhaps there's other reasons for an absence, in which case the chair might say, I'm going to elevate one of the associates to sit on the panel this evening for this particular application. You annually reorganize, and I understand you did that recently to change your chair. And also the ZBA will periodically update and adopt rules and regulations relative to how it conducts its proceedings. Once you do adopt your rules and regulations or revise them, a copy has to be filed with the town clerk's office. So quorum. We get a lot of questions about quorums. And as a general rule, a quorum is a majority of the board. Now, even though you have 2 associate members, you are a 5-member board. So a quorum, for purposes of the board being able to have a meeting, is going to be a majority of 5, which is 3. However, as you'll hear more tonight, 3 members, by and large, is not enough members present for you to enact most of the business that you're required to under state law. Lots of times in Chapter 40A, you'll hear that this requires a supermajority vote. So for a 5-member board, it's going to require 4 of you to vote either in favor or against something. So even though you might have 3 members present on a given night, and you have a quorum of the board, so you could vote to approve minutes or something like that, you don't necessarily have enough members present to vote on a special permit. So in those circumstances, I typically recommend to a board that you should let the applicant know in advance that there aren't going to be enough board members present that evening to be able to vote on their application, so that they could request a continuance and have that hopefully teed up in advance. If you don't have the requisite number of board members present to vote, and you can't get an extension from the applicant, it doesn't really matter. The application is going to be constructively approved because you don't have enough members to approve it or deny it, so they could argue that it's constructively approved. So we've talked a little bit already that the ZBA has the power to grant special permits under Chapter 40A and also under Section 202-6 of your zoning bylaw. Special permits also require that the board's decisions make findings about a particular use or a change or extension. You hear appeals under Chapter 40A, Sections 8 and 15. Those are appeals from an order or a decision of the building commissioner. So if somebody requested zoning enforcement action and didn't agree with the determination of the building commissioner, the second right of appeal is to this board for you to determine whether you uphold or overturn the building inspector. You are the only board that's authorized to grant variance relief under Chapter 48, Section 10. And you are also the only board that can act on comprehensive permits under Chapter 40B. That's the affordable housing law. So I'm going to break each one of these down into a little bit more detail. So special permits, whatever type of application we're talking about, everything begins with the town clerk. So an application is supposed to be filed with the town clerk, and the reason for that is the town clerk dates and timestamps when it is received. That is the official timestamp of everything. That starts the clock for everything that this board must do, because you only have a certain amount of time to open a public hearing, to close a public hearing, and to vote. And that's the date we're going to go by for all purposes, is the town clerk's date. The application then gets forwarded to you. And from there, the ZBA begins the process of scheduling a hearing to hear the specifics of that special permit application. Now, the chair and I, we were discussing just before this meeting began. You see the last point there is that you have 35 days to open the public hearing once you've received an application. That's a little bit different from what Chapter 40A provides. Chapter 40A gives you 65 days to open a public hearing. I understand that there might be some discussion that the 35 days was perhaps a typo. I don't know. I can't really speak to that. I can only tell you that if it's in your bylaw, the only way to change it is through a zoning amendment. So if it is a typo, then some action should be taken by town meeting to clean that up. But for now, in more than one location, your bylaw references 35 days for opening the public hearing. Sure. Yes, it does. So we cannot enact bylaws that are inconsistent with state law, but certain laws we are allowed to be more restrictive or more permissive. I don't really have any background in terms of when that 35 days was adopted. We could certainly look into it and then try to find the Attorney General's letter approving that. It could be that the Attorney General's office said, well, 35 days, yeah, exactly. It speeds the process up. I mean, you'll see when we get to comprehensive permits, state law says you open a public hearing within 30 days. So maybe the Attorney General's viewpoint was, if you want to be faster and more efficient about this, go right ahead. I'm only guessing at this point. Okay. So we just talked, okay. One thing I also just want to mention here is, while your bylaw has the 35-day requirement for opening the public hearing, we also have to, so what does that mean to open the public hearing? It means you're advertising in a newspaper. I think that might be the next. No, maybe not. Okay. You're advertising a legal ad in the newspaper. You're sending notices to abutters and abutters to abutters within 300 feet. You don't have to worry about that. The applicant is going to the Board of Assessors office, and they're going to run it through their database to say, okay, these are all the owners of record who are direct abutters to this property or within 300 feet of the subject property. That generates a mailing list for notices to be mailed out to those folks. But in addition to advertising in the newspaper, we also have to comply with the open meeting law. The open meeting law requires that we post our meetings 48 hours prior to the date set. So unfortunately for planning boards and zoning boards, there's 2 layers of deadlines to keep track of for posting requirements. And according to your bylaw, the clerk of the board, whoever the lucky person is right now, is responsible for taking care of all of those notices and filing any extension agreements with the town clerk. So as I said, special permits, there's sort of a general outline as to what special permits can and cannot do, found in 40A sections 9 and 11 and 16. But by and large, you're going to use section 2.202-6 of your zoning bylaw that really sets out, here's the criteria. And sometimes there are things as generic as whether or not the use is compatible with other uses in the neighborhood, whether or not adequate regard has been given, say, to preserve natural features, that whether or not, traffic and for pedestrians and vehicle safety has been accounted for, things like that. You can put any types of criteria into your bylaw for special permits. The important thing is if you're acting on a special permit, to know what the provision of the bylaw is to help frame your discussion and your decisions, because you want to make findings that's consistent with that bylaw. I've had my fair share of court cases where the judge will remand the case back to the board because the board didn't make the findings they were supposed to make in their decision. So it's always helpful to use the bylaw as a guide. Your final decision, as I was saying a few minutes ago when we were talking about quorum, special permits by and large are always going to require a 4/5 majority, but there are some recent zoning changes that only require a majority vote. Those have to do with housing or mixed uses where at least 10% affordable housing is provided for, and also parking reductions associated with residential uses now only require a majority vote. You have to take final action within 90 days of closing the public hearing. What that doesn't quite say is that you can take as long as you want to conduct the public hearing. Special permits are the only one where you get an unlimited amount of time, basically, to conduct the public hearing. But once you've actually closed the public hearing, you've got 90 days to deliberate and render a decision. Once you vote, you've only got 14 days to file your decision with the town clerk. Yes, sir.
That is different with the 40B though, right?
Absolutely.
Right, because there is a time limit to close public hearing on.
You're absolutely right. And I think we do cover that a little later.
Oh, okay.
But yes, yep. Just a general note that, if deadlines are not met or if extensions of deadlines are needed, but we don't obtain them in writing, an applicant can always seek constructive approval or constructive grant. What that essentially means is there's a process built into the statute where an applicant can say, the board didn't open the public hearing within 65 days as they were required to, or the board closed the public hearing 100 days ago and they haven't voted yet. So they could effectively start a process to assert that their application is granted as is without any conditions that you might have been entertaining along the way because we missed a deadline. So make sure if you need any extensions, make sure they're in writing, make sure they get filed with the town clerk's office. And a standard provision is that all of your decisions, and I'm sure they do, have to include a provision that appeals can be made within 20 days under Chapter 48, Section 17. So under your specific bylaw, this is the 202-6 section, and the criteria that are built into the zoning bylaw for evaluating whether or not particular use should be entitled to a special permit. So you can see them there. There's only 4 of them, but you might want to consider adding to that in the future. Conditional approval. Special permits by statute, you may impose conditions or safeguards or limitations on time and use. So some examples would be if there's going to be phased construction, maybe you want to put some sort of deadlines around the construction so that we don't have a construction site ongoing for, say, 6 straight years. You might decide to put some sort of requirements about parking or limits on types of vehicles. I know a standard one that this board has used is that for some of the 40Bs that we've done, We have prohibited recreational vehicles from being parked on site because that takes parking away from the cars or the guest parking spaces that you need. There might be conditions put in about maintenance, that we want to make sure that if you've got a stormwater maintenance infrastructure on that site, we want to make sure that we've got an operation and maintenance plan. We want to make sure that someone is making sure that that operation and maintenance plan is followed, that the systems are inspected. If someone was required to put in a rain garden, we don't want to find out 3 years from now that somebody thought it was just a depression in the ground that they have filled in and that no longer works for its intended purpose. You might also put some limitations in about a bond or the hours of operation, particularly for some type of a commercial use, for example. You also have a couple of provisions with respect to specific sections of your bylaw that go into certain types of conditions you might consider. But this is just something, it is one of the tools in your arsenal, like how you can better shape a particular project. Yes?
The petitioner has the right to hear the petition as presented, right? So the conditions, I realize we could just vote it down, but he does have the right to have that petition voted on as presented, correct?
Right, and in the context of you hearing their petition, you might discover that there's an issue of some sort. Like the place that they're proposing that all of the parking is going to be located is going to generate headlight glare that's going to shine into somebody's bedroom. So you as a board might decide, okay, we're going to require that there be some kind of fence, some kind of landscaping that goes there. Or we might even say, you know what, could you move the parking over to another location on the plan that isn't going to have that impact? So even though you're considering the application as presented, you get to tweak it a bit, and you can do that through conditions.
Can the conditions be appealed?
They'd have to appeal the whole decision. There's no such thing as just appealing the condition by itself. So you might grant a decision, grant a special permit with conditions, and the applicant will still, although they might be appreciative that you granted the special permit, they will still appeal the decision because that's the only way they can challenge a particular condition that they might think is onerous, for example. I think it depends what the condition is. I've never seen a developer appeal, fencing, landscaping, that type of thing. One that sticks out in my mind is a particular redevelopment of a commercial property that was located kind of at the intersection of 3 communities. And the condition that was placed upon it was that all trucks coming into and out of the site had to go through the 2 surrounding communities. In other words, the town granting the special permit said, you can't go through and use our roads. You can imagine that made that town particularly popular with its surrounding communities. And the applicant looked at that and said, what are we supposed to do? Bring everything in by barge, up a river? I mean, how are we supposed to do this then? So they did appeal the decision. And after a judge giving me a very stern talking to about what is a reasonable condition, we managed to negotiate a settlement on of that particular condition. So it doesn't happen very often, but that would be the mechanism. You're welcome. So special permit can also be conditioned as to its duration of time or even the ownership of the applicant. We saw this come up in the marijuana context, where it was very important that where we vet the business and the individuals, say, for example, who are operating a marijuana establishment, we don't want just the next, I'll use my mother's terminology, fly-by-night operation, just come in here and then replace the entity that we vetted. So you can place some conditions when it seems to be important to the use, to the ownership of the particular special permit as well. And I added up there that unlike a variance, so you're going to see when we get to the variance section relatively soon, that the statute applying to variances was completely repealed and replaced by the budget. And where we used to have the ability to impose conditions on a variance, that language was completely removed from the statute, leaving us either to say, was that intentional? Perhaps yes. Or leaving for another day a zoning board that might just say, well, we're going to impose a condition and let's just see what the courts say about this. So stay tuned. Special permits, and this goes for variances as well, they don't take effect until they're recorded in the registry of deeds. So typically a special permit condition will always require that before a building permit can be issued, that they have to provide proof that the special permit has in fact been recorded at the registry of deeds. Why does that matter? It goes to the chain of title so that we know what a particular property is allowed to do or not do. Something that is unique to special permits, however, is that they can be exercised at risk during an appeal period. So there, with a variance, for example, if a variance was appealed, there is no going ahead and building the addition onto the house or whatever the variance granted. A special permit, however, the applicant is allowed to proceed at risk. And if the applicant loses the appeal, well, the applicant may very well have to tear down and lose money that they've invested in improving their project. Under your zoning bylaw, special permits can also be conditioned on a requirement that they be exercised or within 2 years. That actually was amended a few years ago under Chapter 48. You could now go up to 3 years to allow someone to do that. So variances. So we're only going to focus really on dimensional variances because, as we said, use variances have to be specifically authorized by your bylaw. Plymouth does not, so we won't spend too much time on that. So dimensional variance is basically just what the name implies. It's this board granting permission to someone to deviate from some kind of dimensional requirement set by the bylaw. It might be, or typically is, allowing for a reduction of a setback, or someone needs to build a building higher than the bylaw provides for maximum height. It might be exceeding maximum lot coverage. It could be anything that we dimensionally regulate. If the project does not comply, they have to come to this board for a variance. A use variance, on the other hand, would actually allow a use that is not otherwise allowed in the zoning district. And the example we had up there is, say, allowing an Amazon warehouse to locate in a residential zoning district. Plymouth, where you don't allow use variances, we don't need to worry about that. Same process again for variances as we saw with special permits, that everything begins with filing with the town clerk, who stamps it in received, and then off it goes to your administrative assistant, who distributes it to the board, and the public hearing process begins. Just like we were talking about with special permits, the bylaw here provides that we have to open the public hearing within 35 days versus the 65-day requirement under state law. And as we mentioned earlier, you've got to also comply with the open meeting law. So for those who have been on the zoning board for years and you've seen your share of variances come, you've probably gotten used to the variance standard being that there has to be some sort of a hardship that makes strict compliance with the bylaw next to impossible, and that the hardship somehow or other has to be based on shape, soil, or topography of the lot. That has been replaced as of July 1st. So now the standard is whether strict enforcement of the bylaw would result in a practical difficulty. And we now have to weigh the benefits to the applicant and to the public interest, which, as you see, includes the production of housing, as compared to the detriments to the public health, safety, and welfare of the neighborhood that's impacted. And then it goes on to say that the board may consider whether the practical difficulty relates to soil, shape, or topography. So it does hearken back to the prior language. But now we soften it a little bit to whether strict enforcement imposes a financial hardship on the applicant, or whether the benefit sought by the applicant can be achieved by some other feasible method, and whether the practical difficulty was self-created. I will tell you that in the 1 week since this new standard has been out, that the planner's listserv has been going absolutely crazy, where the conventional wisdom is, so everybody gets a variance now? Or when isn't the basis for a variance self-created? All fair points. And all I can say is we're going to see how this plays out in some communities. Yes.
So a lot of attorneys say, never apply for a variance ever. You always just apply for the special permit. You'd be crazy to apply for a variance in Plymouth, and that just push it through with a special permit, and the director won't know the difference. And so there'd never be a variance applied for unless they're really egregious. So in 16 years of being on the board, I think we've seen 2 variances.
Before that, we used to turn down quite a few appeals.
So it's basically stopped. And it was Dick Manfredi that used to say he needed a variance. And then when he retired, all the variance applications stopped.
It was a very, very high standard. And that's,
So can you tell us when it would be a difference, when you'd apply for a special permit as compared to variance? 'Cause that's quite the gray area in Plymouth.
absolutely. And now it's probably gotten even more gray, because I would say with this new standard that some local practitioners out there who maybe previously were advising clients, no way, no how, you're never going to get a variance out of the Plymouth ZBA. They might now look at this and say, maybe we do have an opening here.
They still would apply for the special permit because it wouldn't make any sense.
They might still just do that,
So
right?
that would-
In which case, it kind of just nullifies the variance altogether.
Can I make a comment?
Sure.
The next meeting, we have a variance application.
All right, so save a copy of this page.
It's a dimensional one.
And the games will now begin, yes. So variances still require a supermajority, so 4 out of 5 of you would still have to vote to grant it. Unlike a special permit, you have to take final action within 100 days of opening the public hearing. That actually says the date of the filing with the town clerk. I thought it was from the public hearing. We'll take another look at that, make sure that's right. Once you actually vote, you've got 14 days to file the decision with the town clerk. Same thing about any extensions or getting them in writing from an applicant, just to avoid any claims that your variance application has been constructively approved. And then again, it's the same appeal period. They've got 20 days after the decision is filed with the town clerk to file an appeal. Variances also have to be recorded in order to take effect. Up until July 1st, variances lapsed after 1 year if they were not exercised. As of July 1st, that has been extended to 2 years. You also previously had the ability to grant an extension of a variance of up to 6 months. Now a variance can be extended for up to 2 years. So you'll see we still have the language in there from section 202-5 of the zoning bylaw which has the old language in it. I suspect we're going to be talking with folks in the planning department about some zoning changes to come at an upcoming town meeting.
So it's under the bylaw, the decision on application of variance shall be made within 100 days after the date of the bylaw.
Okay, all right, so that is the bylaw. Okay. So that's still consistent. All right, so 48, Section 6, non-conforming structures and uses. In full disclosure, this is my absolute least favorite statute that I've ever read. And I'm not alone. There are a lot of, there's one judge whose decision I love to read. He calls it the most infelicitous language of Chapter 48, Section 6. So if you remember at the very beginning of the presentation, we said this is the process you go through to adopt a zoning bylaw. Well, the moment you adopt a zoning bylaw, you inevitably render something or someone's lot or some use non-conforming. So it automatically gets dubbed with this title of pre-existing non-conforming, and you'll hear that term used a lot under 40A. Now, just because a bylaw has changed and rendered something pre-existing non-conforming, they're allowed to continue their use. They're also allowed to expand their use. And up until July 1st, pretty much any expansion of a pre-existing non-conforming structure or a pre-existing non-conforming use made its way to the Zoning Board of Appeals for you to grant what's called under Chapter 48 a finding. But under your bylaw, it's a form of a special permit. But the finding is typically that the proposed alteration or extension is not substantially more detrimental to the neighborhood than the existing non-conforming structure or use. With some recent changes to 40A Section 6, a non-conforming structure or a residential use is allowed to be extended or altered as of right. So it's not going to be coming before this board for a finding or a special permit, provided the extension or the alteration complies with current dimensional requirements regarding height, stories, and setback. Now, it doesn't say what happens to other types of dimensional requirements, such as floor area ratio or minimum open space or maximum lot coverage. So I think we're going to see some litigation or perhaps some further legislative changes that clarify that. But the idea behind this is to reduce the bureaucratic red tape, if you will, and to make some development a little bit easier. And so this will fall to your building commissioner for most of these different types of alterations. So as we said, under your existing bylaw, the Board of Appeals grants a special permit to allow a pre-existing non-conforming structure to be altered. And then a pre-existing non-conforming use or structure, which has not been used for a period of 2 years, loses its protected status. This is typically called abandonment or maybe even discontinuance. Recent legislation has just moved the goalpost so that abandonment is now after 4 years rather than 2 years. So you can start to see the trend. Everything's getting a little bit more development friendly. Continuing on also with your own bylaw, about pre-existing non-conforming structures being enlarged or altered. Again, I think this is a section that we're just going to have to look at through the lens of the recent legislation to see if any of this language perhaps needs to be revised to be consistent. But at least for now, it appears that with respect to commercial uses, that if a commercial use is pre-existing non-conforming and they want to expand their use in some way, for example, go back to my gas station in a residential neighborhood. Well, gas stations aren't just gas stations anymore. They're convenience stores and they're car washes, and sometimes there's also an automotive repair component that might go with it. Sometimes you even see that they're a small used car lot as well. If the gas station wants to branch out into any of those types of additional uses, they're still going to have to come before this board for a special permit under the bylaw. Constructive approval, we've talked about this a little bit, and that's just regardless of whether we're talking about a variance or a special permit or even a comprehensive permit. It is essentially anytime we fail to act within the time frame that we're required to act, an applicant can seek constructive approval, which basically means that their application is approved as submitted with no conditions from us. So it's always important to keep that calendar and know what your time frame is. So appeals under 40A, Section 8 and 15. These are appeals, as I mentioned earlier, from an order or a decision of a building commissioner. Maybe a building commissioner has issued a building permit and an abutter disagrees and feels that, nope, you can't have a building permit for that. You need a variance to do what you're doing. Or someone has been denied a building permit and they think they're entitled to it. They can appeal to the Zoning Board of Appeals. Essentially, what this board does in that situation is you are voting whether or not to uphold or reverse the determination of the building inspector. And one thing I just want to point out here is you might even hear appeals, for example, the building commissioner might issue a cease and desist order to some property owner claiming that they are in violation of the bylaw in some way. And the property owner disagrees, property owner may appeal to this board. One thing to just bear in mind, you're only hearing appeals of a building commissioner's determination as they arise under your bylaw, not having anything to do with the state building code. So for example, if the building commissioner told a particular property owner, you need to install a sprinkler system in this particular use, and the developer disagreed with that determination, that's something that is exclusive to the state building code. There's a separate appeals process to the Board of Appeals under the state building code. That does not come to this board. So similar to the process is that anyone who is aggrieved by a decision of the building commissioner has to file their appeal within 30 days of the date of that decision, indicating the grounds for the appeal, and they have to provide a copy of the decision being appealed to the building commissioner. And once that reaches the Zoning Board of Appeals, we have 65 days to open the public hearing on and just get that process going on whether or not to uphold or reverse the building commissioner. I think just because your bylaw doesn't specify. Right? Overturning or upholding the building commissioner requires a 4/5 vote. If you fail to get a 4/5 vote, let's say your vote is 3-2, building commissioner's determination stands. You need at least 4 to overturn. Similar to a variance, the board has to make their decision within 100 days of receipt of that application for or otherwise constructive approval could also apply to an appeal. There's a further right to appeal if somebody is still aggrieved by the zoning board's decision. Let's say they didn't like what the building inspector said and the zoning board voted to uphold the building inspector, they can then take it to court as their next level.
So I had a question. Earlier, you talked about constructive approval in the setting of not having quorum or 4 members present. Is there an equivalent disapproval process if you don't have a quorum present?
I really wish there was, but no. Everything always seems to be, if we, meaning we, the town, don't do what we're supposed to do within the time we're supposed to act, then somehow or other we get penalized. The you're not having a quorum, and let's suppose something is voted that night, the applicant, for some strange reason, you've only got 3 members who are present on a given night. And you've got an applicant who says, I'm not going to grant you an extension. I can't imagine why they would do that, because they know they need 4 votes to grant them their relief. But stranger things have been known
Well,
to
unless they
happen.
get constructive approval. So on the constructive side, I would not grant approval if I were the
No,
applicant, right?
I know. I understand, but no, there's no mechanism for that in the zoning act.
Okay.
We have to make, an affirmative decision, and lacking that, the developer or the applicant's application is approved.
Okay.
So repetitive petitions, this is something that doesn't come up very often, but you should be aware of it, that once you have actually denied someone's application, it cannot come back for 2 years. Now, unless, so if it's materially different, it might still be the same property, they might still be looking to put, an addition onto the property, but if we could make an argument that it is materially different, it is significantly smaller, for example, then it might just be materially different from what you denied, that the board could see its way to entertain this new application, notwithstanding that 2 years has not passed. But sometimes an applicant will come back with the exact same application. And the idea behind this section 16 was to stop a situation where an applicant would just refile and refile and refile and refile. You could be literally entertaining the same thing over and over and over again. And so the legislature put this in place so that we get some breathing room after something has been considered and denied. However, if a petitioner refiles, the only way they can overcome this repetitive process would be that the zoning board finds by a 4/5 vote that somehow there's very specific and material changes from the application that had been denied. And all but one member of the planning board has to consent to the application coming back before the zoning board. Even though the planning board may have had absolutely nothing to do with the original application, this is just sort of a little bit of a check and balance so that there's a higher bar for a would-be repetitive petitioner from bringing something back. The statute doesn't really, you need both the zoning board to vote 4/5 in favor, and you need the planning board to vote. The statute doesn't say which one has to come first, but from a practical standpoint, seems to me you'd want them to go to the planning board first and make sure that you get the consent of the planning board, because if you haven't got that, why should the zoning board bother to have a whole new public hearing on something? The zoning enforcement process. So we've talked a little bit about this with your building commissioner being your zoning enforcement officer. And anyone could make a written request for zoning enforcement. Sometimes I've had folks say, that person lives clear across town, and yet they're asking for zoning enforcement relative to this parcel of land. Doesn't matter. Anyone can request the zoning enforcement. And if the building commissioner declines to act, the building commissioner has to let the individual know of the refusal within 14 days. And then that aggrieved person can appeal to the zoning board to reverse or try to reverse the building commissioner's determination. This is also contained in section 202-12 of your zoning bylaw, and it does also elaborate a little bit more as to the authority of the building commissioner when it comes to zoning enforcement. This really isn't something that's necessarily going to involve the zoning board, but just to let you know that the building commissioner has the ability to issue orders, to issue a stop work order or a cease and desist order. Building commissioner might also fine someone. There are lots of times where we will, after a certain period of time, of trying to work with somebody at the local level and sending them notices that they simply disregard, we can take them to court with the building inspector, and often we do, to get a court order to make somebody do whatever it is that the bylaw requires. Again, not much of a role there for the zoning board, but just to be aware that there's other options for the building commissioner. So when it comes to enforcement, there are two provisions in Chapter 48, Section 7. This first one here has to do with a structure or use that has been undertaken in accordance with the building permit. In other words, something was built and a building permit had been issued, or a use was begun and a building permit was issued for that use. Yet, something that happens in the process of exercising that building permit and what you ultimately get does not comply with zoning. So a common situation that arises is that a building permit is issued for a structure and the shovels are in the ground and suddenly the building has shifted over a few inches. And now those few inches are encroaching into perhaps a setback. That's a situation where the building permit on its face was properly issued, but it's not until construction has begun that you know that there is a violation. The building commissioner has 6 years to take zoning enforcement action in that situation. There is then the 10-year statute of limitations. This is when a structure has been erected without the benefit of a building permit. And this happens all the time, that people just see what they perhaps can get away with, or I didn't know I needed a building permit for that shed or whatever it was in my backyard, and nobody sees it. Well, more than 10 years pass, we are now out of luck and we can take no enforcement action against that structure. And at that point, these otherwise unlawful structures are deemed to be legally non-conforming once that 10-year period passes. The 6-year, I think it really is just about notice, to be honest with you, because the 6-year is a building permit was issued. So we as the town knew something was being done on this property. And then there should have been inspections, regular inspections that were done along the way, and then ultimately resulting in an occupancy permit. So you get less time to bring enforcement action for when a building permit is issued. And I think the rationale is because we had an opportunity to check that this was in compliance with zoning, versus the 10-year enforcement limit is something was put up and there was no building permit. So you imagine, something that is a heavily wooded lot, setback from the road, and, maybe in somebody's backyard and obscured by whatever the structures are in the front. If a building permit wasn't issued, and if no neighbors ever saw any activity or reported any activity, something could go on in a backyard for years and no one notices. Well, now, if 10 years passes, we can take no further action. But then if they want to add on to that otherwise unlawful non-conforming structure, they do have to come to the Zoning Board of Appeals for a special permit in the future. It's not exactly adverse possession, but it is granting those structures non-conforming status as if they were lawful. In other words, we've got 10 years to exercise our right to enforce. We didn't do it. We've now, forfeited that right. So comprehensive permits, this is going to be a very cursory review, a couple of slides, because as I said, I could do a full hour training on these, and we don't need to. And for those who have just lived through the most two recent 40Bs, you don't want me to. So So unlike Chapter 40A, this is Chapter 40B, and this is the Affordable Housing Statute. Unlike everything that you have heard tonight about how special permits or variances work, you can throw all of that out the window, because if an application for 40B comes in, it is unlike anything that you typically administer, including the deadlines. So if a comprehensive permit, as its name implies, it is a single permit that encompasses all of the local permits that you can imagine would be issued for a particular project. So the zoning board acts as the planning board, even in the case of, say, a subdivision that might be part of the project. You act in place of the Conservation Commission when it comes to your local wetlands bylaw. You may act in place of your Board of Health on certain local health regulations. You administer all of the zoning bylaws. You might even act in place of, say, the Select Board on other types of permits, like an earth removal permit. You will find yourself in a rather uncomfortable and uncharted territory, in that you are evaluating things that have always been in somebody else's purview up until this type of application comes before you. The only thing you don't act on is anything having to do with the building code or any issues of wetlands that are strictly a creature of the State Wetlands Protection Act, or anything having to do with septic systems under Title V as opposed to your local bylaw. But suffice it to say, you act in place of all local boards in issuing all of the local permits under all of your local bylaws and regulations. Unlike other permits that we've talked about tonight that require a supermajority vote, comprehensive permits only require a majority vote. And that goes for both granting the permit as well as waivers. You'll hear an awful lot in the context of a comprehensive permit. The applicant is allowed by state law to literally override all of your local zoning. And the applicant is required to submit a list of what they call waivers or exceptions. It has to come in with their application, where they have gone through all of your local bylaws and zoning bylaws, and they've identified every single one that they know they cannot comply with. And you're going to have to go through them and decide whether or not to grant those waivers or not. All of that subject to a majority vote. So for comprehensive permits, the zoning board should adopt rules and regulations. This might be one of those times where it's important to perhaps have some regulations pertaining to comprehensive permits, because sometimes there is a procedure that's laid out for things like, you're going to need technical peer review. The fee that gets assessed for a comprehensive permit should be different from a fee for just a special permit, because your breadth of analysis is so much more than it is typically in a special permit. You're going to want to notify local boards, but you're also required to notify all the other boards when an application comes in, because you want their feedback. Because, as I said, you don't typically act as a planning board on a subdivision matter, so you might want some comments from the planning board or your DPW that helps you with, I don't know, the grade on a roadway crown, or what's the benefit of granite curbing versus Cape Cod berm. You have to open the public hearing within 30 days of that application being received. You have to close the hearing within 180 days of the date that you open the hearing, unless, of course, an extension is granted. And again, if we miss that deadline, or we don't get extensions from the applicant, we're at risk of a constructive approval. So you want to avoid that. Once you close the public hearing, you've got 40 days to deliberate. And then once you actually vote, you've got 14 days to file the written decision with the clerk's office. So a couple of other things we're just going to touch upon, just because there've been some recent changes, and we've got some questions through the planning department. Accessory dwelling units, as you all know, as of 2024, every single family residential district is allowed to have an accessory dwelling unit by right. So that means it's going to be approved by the building commissioner. I don't really see much of a basis for accessory dwelling units ever coming before this board, unless, of course, you have an applicant or an abutter who perhaps disagrees with an interpretation that the building commissioner has made under the ADU bylaw. But by and large, this board won't have much of a role with respect to accessory dwelling units. We've also had the MBTA Communities Act, or Plymouth in 2024 adopted multifamily, a district of the appropriate size as determined by the Executive Office of Housing and Livable Communities to allow multifamily housing by right in those identified zoning districts. So again, because they are by right, there won't really be much of an opportunity for them to come before the Zoning Board of Appeals. There are also some other things. You will often hear the reference to the Dover Amendment. The Dover Amendment is Chapter 48, Section 3, and the Dover Amendment essentially places some limits on what a town can and cannot regulate. So, for example, religious and nonprofit educational institutions, we cannot prohibit them, we cannot require a special permit for them, we cannot unreasonably regulate them. The question becomes, well, what is a reasonable regulation? And I guess it's sort of like, beauty is in the eye of the beholder. Some communities do outline certain provisions for Dover protected uses, and maybe they grant some leeway to a building commissioner to determine, find the use in the use table that most clearly resembles this type of use, find the parking requirements that most closely would apply, and impose reasonable regulations. Other bylaws don't have that level of detail, and often a building commissioner will get a zoning project, a Dover Amendment project that will come before them, and the building commissioner does not want to be the one and only person in your community that is deciding what is a reasonable regulation to impose. So by default, they often will refer those types of applicants to the zoning board. And then it is up to you to decide what is a reasonable restriction. Now, there are only, I think, 8 categories, like bulk, height, parking, setbacks. You're limited in what you can do, and it's all very much dimensional in nature. Sometimes a Dover protected use will file with the Zoning Board of Appeals under what they'll call a reservation of rights, because they will claim that their Dover use cannot be denied. It can only be reasonably regulated. So in the event that the zoning board might do something really crazy and try to deny the permit, they will sometimes say, I'm applying to be a good neighbor, but I'm reserving all rights. I don't really need to be before this board. But if we're all willing to agree as to what is a reasonable regulation for this use, no harm, no foul type of thing. Something else that we've been seeing more and more is the focus on solar and clean energy in particular. The courts have also been very active with respect to solar. You'll find solar referenced in Chapter 48, Section 3. We are allowed to require a special permit for solar, but we can't unreasonably regulate solar. So we've put the Tracer Lane versus Waltham case up there because that case was really the one that has kind of spurred a lot of discussion and examination of solar bylaws throughout the state, because Waltham, although they allowed solar installations, they only allowed solar in about 2% of their land area. And when you actually looked at sites that had a large enough acreage to qualify, the court said this is essentially akin to a prohibition, that there is no place for solar to locate. The town of Walpole has a similar appeals court decision against them for not being open enough to solar. Community to the north of you had a battery energy storage system case come in, and some courts are also considering battery energy storage systems to be akin to solar and therefore protected. Town of Duxbury disagreed with that, and the applicant appealed that denial of a battery energy storage system to the appeals court. We were really kind of looking forward to trying that, arguing that case with the appeals court, because we think the land court got it wrong. But unfortunately, the applicant in Duxbury pulled out, so we'll have to wait for another day to find out how far we can go with regulating battery energy storage systems. Meanwhile, in 2024, the legislature passed the Climate Act, such that certain clean energy facilities, and basically it's solar, wind, battery energy storage systems, and anaerobic digestion facilities, or other clean energy facilities that will later be identified by the state, if they are above a certain generation or storage capacity, there is no local regulation of them anymore. They all go straight to the Energy Facility Siting Board. But below a certain threshold, they come to the town. Yes, sir.
What is this battery energy? I mean, is it a building full of batteries?
I think of them as, and the size is going to depend on the capacity, but maybe the best way to think of them is almost like generator pads. And you can see, a residential generator that fits on a pretty modest concrete slab outside of somebody's house, yet you go to a larger building and that, generator could be almost like the size of a small, a trailer like for a truck. They vary in size based on their storage capacity, and they are typically associated with solar arrays. But once they're connected to the grid, they're storing electricity from any of the sources that generated it, whether it's hydro, solar, wind, could be coal-fired too. And those are gaining some popularity, particularly out in, say, the western part of the state, where they're seeing battery energy storage farms popping up, basically. Yes.
Do you know what the size is to go straight to the Energy Facility Siting Board? Don't want to put you on the
It
spot.
is, I'm probably not gonna get this exactly right. I want to say something like 25 megawatts of generation, and I think 100 megawatt hours of storage. But I can get you that exact threshold. Sure. Typically, but they are also now, we're seeing them as standalone uses as well. That they are clearly connected to the grid somewhere, but, originally we were seeing these with solar facilities, and then the batteries were almost like an accessory structure with the solar arrays. Now we might just see battery energy storage systems as a standalone use, wherever they're getting the energy from and storing it, and then passing it back along to the grid.
So a lot of this stuff seems to be dictated by case law as opposed to actual codified into the law.
Right.
So does that give a zoning board a little more latitude to act to their best judgment because there's really no clear legislative intent that they're following?
It does until an appellate level court rules on it. And then whether we like the decision or not, it becomes binding across the state.
Okay. But it sounds like there are a lot of areas that just haven't been adjudicated yet. Is that? correct?
That is correct, because there's, I think this is more like, this is still an evolving
Right.
area. I mean, 5 years ago, I remember seeing like the first battery energy storage system bylaw pass my desk, and I think a lot of us were like, what the heck's this? You know, and now, yeah,
But I mean, if we just view that as a legal motif for other evolving technologies or whatever,
right.
it's kind of like you can just do your best is what it sounds like. And
Yep.
then let you guys earn your money.
Well, even if you,
Defending
and even if you think about it, you know, like even going back to say, if we could all turn back time to before Plymouth adopted zoning, and if we had a blank slate and we all sat down and said, okay, let's, we've just carved the town up into our various zoning districts. Now let's develop our table of uses. Well, we'd all come up with, you know, the same list of, you know, single family, two family, multifamily, certain scale of businesses and, you know, warehouses or industry. But how many of us were thinking about battery energy storage systems? Nobody. So you try to figure out, well, what might be the closest category that would fit, or can we say that it's prohibited? It's usually new, you know, evolutions like this that cause us to suddenly amend our bylaws to put these uses in, because we'd rather regulate them than not.
Right.
So this, I'm going to take a seat and let you turn it over the reins.
Okay. So I'm gonna get a little bit into, I know Carolyn mentioned you're subject not only to these rules about public hearings under your zoning bylaw and chapter 40A, but you're also subject to state laws governing different procedures. So that's the open meeting law, that's the public records law, and that's the conflict of interest law. And those three together are known as the sunshine laws. They were, as their name implies, they were passed to make rules and requirements so that public bodies can be more transparent for the public. So public hearings, all of your actions occur, where's my remote? Within a public hearing, but additionally, the open meeting law. And so public hearings has its own requirements. They can't be held on the day of a state or local election, a caucus, or a primary. It requires advertising notice in the newspaper twice in successive calendar weeks, and first with a notice of at least 14 days prior to hearing. You're required to post at the town hall, and the day of the hearing does not count towards the 14-day requirement. You have to mail these notices to the parties in interest. And in addition to that, you also have to notice your meeting under the open meeting law. So that's 48 hours in advance, and that's business hours. So public hearings, they consist of several dates and sessions. They can be continued, but they must be continued to a date certain. Otherwise, if they're not continued, you would be required to re-advertise and re-notice to abutters. So we recently actually had a problem with another board where they didn't properly notice the meeting under the open meeting law. And so it wasn't properly continued. And so they ended up having to issue re-notice and re-advertise the public hearing. And then board members who missed one public hearing session cannot participate and vote unless they have something called a Mullen certificate. In Plymouth, you're not allowed to do that. The zoning board has not adopted the Mullen rule. And then all votes of the ZBA must be public. There can't be any secret ballots. So everything must be in open session. And in certain cases, under the open meeting law, you're required to do roll call votes. So you can't just have, say aye, each board member has to go down the line and say aye or nay. Public hearings, they must be closed by the time the statutory deadline runs, unless, again, there's an extension agreement. Once a public hearing is closed, the board can't consider any other evidence. So That also means that the rights of the public or the applicant to speak is over. As a practice tip, it's important that you make sure that you have all the information you need before you close the public hearing. You don't want to be caught out in a situation where you still have questions of the applicant and you're not allowed to ask them because the public hearing's closed. You're not allowed to take any more testimony. On the other hand, if you have a particularly rowdy public, you can vote to close the public hearing as a way of signaling them that their portion of participation is over, and at that point, it's just up to you to deliberate.
So, I
Yeah.
apologize.
No.
Yeah, can you take, can you send written queries and get written responses to council once a public hearing is closed?
That would be considered new information.
Right,
So,
okay.
yeah, so at that point, you can if the public hearing's closed.
Okay.
Exactly.
That one's hard to explain to people.
Yeah, you could
It's hard for
do,
them to accept, let's put it that way.
yeah, if it's not considered new information, if it's potentially like just
Well,
clarifying
that was
something.
where I was,
That they've already said, or if it's just strictly procedural, or maybe, if you're drafting the decision and it's,
so
a
you
question of
said
to
paragraph
form.
3 on page 47 is unclear. Did you mean X or Y? Would that be allowed or no?
That's clarification.
Yeah.
Right, as
Decision
long
that
as
would
it's-
be allowed.
Right.
But to say, oh, and here, and we just happened to prepare a whole new plan that would revise post the closing of the public hearing. No.
We just ran into that
Yeah.
a couple of weeks ago.
Mhm.
And that's so I'm gonna pose a question to you after in a second here, but, because we did run into that on one of the last cases. And once we've closed the hearing, we couldn't take new testimony. So, but again, you can clarify, it. If it's been read in a public comment, you can get clarification. And I'm not gonna get into the case because you never know when it gets litigated. One question I do have for you though is, okay, so if I have a crowd here that's a little, or getting repetitive, can I use the wording, I'm going to close tonight's portion of the public hearing, but if we vote to continue, I will reopen public hearing, that would continue it, right?
So I wouldn't suggest phrasing it that way, because you don't want it to get, because as long as the public hearing is open, the public has the right to participate. You're allowed to set certain restrictions on like timing, place, manner. So you could
Right.
say, I'm gonna give each person 3 minutes to talk and you're only allowed to talk once. You could set those kind of parameters, but yeah, I wouldn't say I'm closing public comment for this meeting. You'll get it next time, just because it muddies the water a little
Well,
bit.
the
as
only
to
problem is sometimes, because I don't want to get caught in that position we got caught in last time, I want to be able to keep it open, because sometimes we do have a crowd that gets a little either repetitive or gets out of control,
You say
basically.
sometimes?
Yeah, yeah. So, I was thinking with those wording, I could close it down for the night, but I'm leaving public comment. So if any new testimony or we decide to continue it, I will reopen the public hearing.
I would make sure that you set those parameters ahead of time before anybody even starts speaking. So that way, you don't get accused of cutting somebody off just because you don't like what they're saying. Right? So you could say, we'll maybe we'll allow everybody to speak for 3 minutes each, and we're going to have public comment for a total of 1 hour. And then after 1 hour, we're going to move on. But I would set those guidelines and make it really clear ahead of time. That way, it's not like, oh, so-and-so speaking, public
No,
comments
we don't do that, but it
Yeah,
does. it's-
but you don't want you want to avoid the appearance of
Right,
that's what
right.
you're doing.
Then also, I have another question. I was gonna do this more in an email to you with, okay, so right now, it depends. I'm gonna run everything by the board. We'll take a vote on this, eventually, not right now. But, one thing I was gonna extend the time for 4 minutes only because I felt that 3 minutes, it gets a little whatever. But can I have two different times? I also would rather have for an attorney who's representing the opposition. Can I say, but if they're an opposition attorney, they get 7 minutes, or can I not do that?
Well, generally, they would be representing the applicant, and the
Well-
applicant has a greater right, or not, I shouldn't say a greater right, but
They
generally,
do.
applicants are expected to participate more heavily in the public hearings because they're giving you information that you are specifically requesting or that you need to act on. So,
We give the petitioners the full, whatever they need. What I'm referring to is we do have different lawyers that come in who opposing just about everything, but they're representing, whatever, public that hired them to do it. Can I give a separate time limit for them, or do we have to extend it 4 minutes at a time? Do you want to?
I'm happy to jump in here. I think you could through your rules. If you know that you've got an organized opposition and there's somebody who's going to be representing a group of abutters, you could give that individual attorney a little bit more time than, say, the 3 or 4 minutes that you would give to just, to individual members of the public. It might also streamline some of the discussion rather than hearing from, if that attorney is representing, let's say, 10 abutters, if you're only hearing from one person, might be better to just give that one person a little more time than to say, okay, then we're going to go down the line and we're going to choreograph it amongst the 10 of us where we're going to each take our full 4 minutes and we're going to cover, whatever portion of our arguments or bring our concerns to you. You could do that. I would suggest that, as Haley was saying, though, either revise your regulations to make that clear, or say it verbally at the start of a hearing, that if
Yes,
somebody
right.
has, identified themselves as representing a number of abutters, we're going to give that person a little bit more time, with the understanding that this is in lieu of hearing from all of the individual abutters that are being represented by that one attorney.
Yeah, I usually do. I did when I had to run it when Mike was out. There was one particular case, not going to say what it was, but anyways, they were appealing the building inspector's, commissioner's decision. And I felt that the landowner had a right to say something, but he's actually not in the litigation,
That's a
basically.
great example. yeah.
Right. So what I did was I said, but at the head, when I first announced everything, I went over how I was going to structure everything. And I did say, and this was by Amy's comments, was I recognized that the landowner would be recognized at the end of public comment, but we would give them an extension right up front for that. There's no issue with that.
No.
Yeah, okay.
In the model you just proposed, there's that fascinating concept possibly that could arise if you have 10 abutters, but they've all hired the same attorney. Would it be okay for the chair to give them the option of seating time up to a maximum so that the attorney can speak to the points of law that are concerned, but then they give up their right to speak? Or could they then demand their individual rights to speak? Is there a way to kind of make give them the choice of one or the other, but not both? And it may be actually to the point that I think you're trying to accomplish,
Right.
that if you have an attorney who is versed not only in the facts of the case, but also the law, that, that would be a more effective presentation, I would think, and it would be far more efficient use of our time. Could that be written into an administrative process?
Yep, I think it could. And I think you would want to make it clear, though, too, that if this is designed to be an in lieu of individuals submitting their own or comments or speaking at the meeting, that they are going to be, defer to, through
Proceeding
council.
there, yeah.
It then falls to this board to decide, okay, so what is a reasonable amount of time to give? Because I don't know that it's necessarily a one-for-one, that, as I was saying, if there were 10 abutters and your rules allow for 4 minutes apiece, does that mean we're giving the opposition's attorney 40 minutes?
No, I would
Should it
cap
be
it at
20? Should it be 15?
I would cap it at whatever the appellant had.
I
you
feel
know?
that if I announce it up front like we have been, I think it's sufficient. But I just wanted to make sure that if I gave, again, like I did that landowner that time, his attorney, more time, that's okay legally.
It is fine. I mean, again, none of this is dictated by state law. This is really all how you want to conduct your meetings. And you want them to be orderly. You don't want to hear the same thing over and over and over again. You want to be respectful of everybody's time, including the public's time and your own. So you can certainly set those limits up front. And like I said, you might want to put something in your rules and regulations about if a group of abutters or residents are represented by counsel, perhaps they should make that known to the chair at the start of the hearing so that then the attorney will get additional time to present the opposition's view in lieu of all of the individuals coming forward and doing so.
And we would probably want to know who they are.
Yeah.
Right? Oh, no, you said you were on this list.
Well, but the practicality of it all is, even if somebody's represented by counsel, you think that the bulk of their arguments are going to be made by their attorney. But you won't necessarily know whether there's one person in the group who's, wait a minute, you didn't say everything that I wanted you to say, and I'm going to have some follow-up comments. But it is still going to decrease some of the frequency and repetition.
And then one other thing, I'm just gonna touch base, because you actually touched base on almost everything, but I'm gonna caution the board too, from now on, any emails that you want distributed to the board, I want distributed through Denise. And the reason for that is in the past, once or twice, we've kind of come up on what you would call given testimony without being in public, because even though it's a public record, if it's forwarded to the whole board, it can change the decision, and I was cautioned on that could be testimony, considered testimony. So I ask the board, anybody you want to, she'll distribute it with your name attached, just that's not an issue. It's basically, we want to be able to, like, if it's something that Mike would be the first person to look at, our planning director would say, no, we can't. That's testimony. You can offer it at the meeting, but we can't do it behind closed doors, is my point.
That is a great segue into the open meeting law. What is deliberation?
Oh, okay.
Perfect.
Well, I mean, but that's above this board. The meeting law, boy, I'll tell you, you learn a lot when you're in town government. I mean, town members, it doesn't even apply to us, it's amazing, But, and that one's even just a little more above the open meeting law because it's testimony, and that's the issue.
Yeah, so in addition to it being testimony, right, because you're getting new information in front of you as part of the public hearing, it's likely also deliberation under the open meeting law, because deliberation is an oral written communication through any medium, including electronic mail, by or among a quorum of a public body on any public business within its jurisdiction. And so what that means in your scenario, right? You want to, especially with emails, you want to make sure that you're not giving your opinions or anything that might be construed as your opinions to your fellow board members or a quorum of your board members outside of a publicly noticed meeting, because that would be an open meeting law violation. So again, deliberation includes emails, text, social media, serial conversation. So if you tell a board member something and they tell a board member, the next board member the same thing, and then it gets to a quorum of the board members, that's also considered deliberation. It doesn't include generally procedural things like the distribution of a meeting agenda, scheduling, other materials, documents, as long as, again, you're not expressing any kind of opinion, belief, idea about those materials. So you can forward an agenda. You can't forward an agenda with the comment, oh, I think item number 3 is going to be really tough. We need to get on the same page about that. Stuff of that nature. And then the other thing you're required to do under open meeting law is to notice a meeting. So a meeting is defined as a deliberation between a quorum of the public body about something within their jurisdiction. So anytime you're going to be conducting business among a quorum, it has to be an open meeting and it has to be publicly noticed. So in addition to the notice requirements for public hearings, you also have to create your agenda and post it 48 hours in advance. That's typically with the town clerk or another official posting adopted by the town. Like I said, the 48 hours are business hours, so it doesn't count Saturdays, Sundays, legal holidays, unless it's a true emergency. And a true emergency is basically, you know, like if there's a hurricane outside and I don't know what a ZBA would really need to be acting on in an emergency. This is usually for like select boards, and the town has to take like imminent action. And then public bodies can't discuss matters that are on the meeting notice if it could not have been reasonably anticipated by the chair at least 48 hours in advance. So if somebody from the audience brings up something and you had no idea that they were going to bring it up, you can still talk about it, but it's best practice to say, you know, this isn't on our agenda, we can put it on a future agenda. That way, you know, it's properly noticed and the public has forewarning that this is something that's going to be discussed. So other requirements for your meeting notice, it needs to concern the date, time, location, and a listing of the topics that the chair reasonably anticipates. The topics must be described with enough detail that any average member of the public not familiar with the matter can determine what will be discussed. So to that end, you can't really use vague catch-all topics such as new business, old business, and you shouldn't be using acronyms unless they're properly defined. So you can't just put a meeting notice that says board to discuss A&R, because that's not really going to give the public enough notice of what the board is actually going to be discussing. The meeting notice also has to contain the location, and there's some requirements for where a meeting can be held. So the location of the meeting needs to include the address, a room number. It must be accessible for people with disabilities. This is required by the open meeting law and the ADA. This includes virtually noticed meetings as well. So if you're going to be meeting by Zoom, you have to make sure that the Zoom link is clear on the meeting notice and that it's accessible, that people can click it, and that, you know, they can get in the same way that they would be able to get in through an open door. So if you're going to have a password on the meeting notice, the public needs to have immediate access to that password or a way of getting it, in the same way that if the door was closed or locked, the password acts in the same way as a locked or closed door. So you'd have to have a way to open that door to them. As a practical matter for the ZBA and specifically, when you're scheduling site visits, if it's posted as an open meeting, that means that the site also has to be ADA accessible, which, you know, may pose a problem for people who are in wheelchairs or have other kind of mobility disabilities. And that also means that you're going to need permission from the landowner or whoever site you're visiting to have the public there with you. I don't know a lot of people who want a bunch of strangers on their property. So typically we would recommend don't post it as an open meeting. If you're going to have a quorum at the site visit, don't speak, don't deliberate, and then have a meeting right after the site visit and post that. And then you can discuss everything that's on your mind right after the site visit, and the public can come and participate. Other practical recommendations, don't move the meeting to a different location unless you have a way of posting it, or if it's amending the meeting notice as far in advance, or if you can clearly post it on the door. Like if you're just going down the hallway, that's typically going to be fine. If you're going to move the meeting to like Plymouth North, for example, that's going to be more problematic because you're going to have people showing up here expecting a public meeting, and then having to drive through downtown, in which case, you know, they're missing out on parts of what they came there to participate in. And then again, as we discussed, no locked doors, the passwords. Otherwise,
Can you back up just a
Yeah.
site visit?
yeah.
We've done site visits, right, at some of the gravel permits and stuff.
Mm-hmm.
So that doesn't have to be an open meeting? That would be an executive meeting?
No, it
Or
would
it's-
just be,
Go ahead.
no, so basically, so if you have less than a quorum attending, so in this case, if you have less than 3 people going,
No, we had everybody there.
it wouldn't be considered a meeting. So you could do that. So you could have people do site visits individually, right? In which case it's not covered by the open meeting. If you're going to have a quorum of the board there, you don't have to notice it, but that means that you can't deliberate. So it means that you
Okay.
can't really talk about anything that's going on. You can just observe.
Just listen, the
Listen.
applicant can tell us what he's doing. and
Yeah.
We can just listen.
Exactly. You can listen, you can
Okay.
observe, and then save all your comments for a publicly noticed meeting afterwards.
So just to add to that, you could, it's not like we're expecting all members of the board to be absolutely silent at a site visit, and that would be a little bit impractical. You can certainly, when you go to the site visit, ask questions that helps the board, as I say, get your bearings. Where is the driveway going to be? Where is the property line? Maybe they've staked something out for you so that you can see, like, this is the footprint of the building, but this is the, you know, the actual property line. You can ask questions that help you kind of get the lay of the land, if you will, so that you get a better sense of, let's face it, the site visit is intended so that you not only see the site, but you have a better way of visualizing whatever the proposal is, how it is going to fit on this site, or where it's, you know, where traffic is going to flow around. So you can ask those kinds of basic questions, but you can't start to deliberate amongst the board members to say, really, the driveway is going to come in that way. I really would have thought that they'd put the driveway down that other end because it would make for a better, you know, circulation around the site.
Yeah.
Now you're starting to deliberate.
But I guess what I was getting at, we can have a site visit.
Yes.
That's perfectly legit,
Yes.
and have the board there. Okay.
Yep.
So the other thing that you're required to do under the open meeting law is take meeting minutes. And this is required for every single meeting that you have. So it's required for open meetings, it's required for executive sessions, it's required for meetings even where it's a public hearing, it's required for meetings under 40B. Every single meeting, no matter what, you still have to take meeting minutes because they are the official record of what happened at that meeting. So meeting minutes, they must include time, date, location, board members who were present and absent, and then a summary of the discussion on each subject. And so the requirement, it doesn't have to be a transcript, but it needs to be sufficiently detailed to allow a person who wasn't there to reasonably understand what was discussed. Another good rule of thumb is generally the more controversial a topic is, the more detailed the meeting minutes should be, because again, this is going to be the record of what happened. And so if somebody has questions a few years from now about what was going on or what the board was thinking or what the public was thinking on this, that's the meeting minutes is going to be the place where they go. So you want to make sure that that record is there, not only for the present, but also for posterity. Getting into that, again, decisions are not a substitute for minutes. So even though we might give you a robust, comprehensive permit decision that has, you know, lots of input on it, including what the members of the public were thinking, all of those meetings still need their own set of minutes. The minutes also must include a list of documents used at the meeting, which are part of the record. So a document used is anything that was discussed or referenced by the board during the meeting. So plans submitted by the applicant, peer review reports, those would all be considered documents used. And so they must be listed separately in the minutes. Oh, yeah.
Should I be putting the link for the recording in the minutes? I just happened to think of it. No.
How long does the recording last, Denise? Do you know how long it's saved?
The whole, oh, I think it's in perpetuity.
Oh.
It's through PAC TV. So the whole meeting is recorded. Sometimes it's not in person, in a day or two later, it's just the recording, not the actual video.
If it's out there in perpetuity, at least as far as we know, you could certainly include it. The only thing is that the video doesn't become a substitute for your minutes, at least not yet.
Sorry.
So, yeah. Even though there's far more detail in the video, you know, the minutes, you know, I mean, if the minutes were simply going to say the board met on, you know, January 19th and discussed XYZ, see this hyperlink, that's not sufficient enough. But if you're going to prepare the minutes and include all the necessary information and then say the full video of this meeting is available at, that's fine.
So the other requirement under the open meeting law is certification. So at this point, everybody probably should have done their certificate of the open meeting law. So you're familiar. They must be on the form specified by the Attorney General. And it includes all the copies of the statutes, the regulations, everything you need to be familiar with under the open meeting law, as well as copies of decisions issued by the Attorney General as to open meeting law violations for that board within the last 5 years. And so you've all certified, you've signed it, you put it on record. There shouldn't be any problems. Often what happens is this kind of falls through the cracks, and then somebody does a public records request for all of the ZBA members, open meeting law certificates, and then we're hustling to get those certificates done so that we can give them as part of the public records request. Which brings us to what is a public record. So all books, papers, maps, photographs, recorded tapes, etc., received by any officer or employee. So any public body member, any employee of the town is considered a public record. The public record law analyzes the content of the record, not the form. So it doesn't really matter what form it comes in. It's more that it's something that was submitted to the town, and now it's a public record. So emails discussing public business, even if it's on a personal email account, would be a public record. So a good practice, if you don't have, is to always use your official email address, especially if it's something that you're discussing for board business. If you don't, CC a town employee on it, so that way at least everything is getting saved to the town servers. So if you do get a public records request, you don't have to search in the search bar of Chrome or Outlook trying to find what is responsive to their public records request. It can just be done through the town's IT. And that way you know it's everything saved where it's supposed to be. Volunteers, they're still subject to the public record. Similarly, text messages, even on personal phones, are public record. And it includes handwritten notes, memos, video recordings, etc. Social media is a public record. This is going to be less relevant to you, but the town should archive all social media posts. And then more relevant is don't post on social media if you don't want it to become a public record, and don't post information that should not be a public record or out in the public. There's some exemptions. Yeah.
So I'm just going to make a point and ask a question to either one of you could answer it, is, so again, when we go to these depositions and they're asking us, about our emails, so on and so forth. When can they subpoena those? In other words, because they can subpoena, emails and a, text, basically. When can they do that and how does that work?
Always make a phone call, don't send an email.
Yeah, exactly.
Yeah, I would say
Always
Don't
make
do
a phone
anything,
call when you
make it-
can, yes.
Make
Yeah,
a
and
phone call,
also-
meetings, never do anything in, don't ever send emails. Very simple stuff. That's just a general rule. Never, that's just simple.
Sure.
Anything you don't want your wife to know about, don't.
But in answer to your question, even outside of a subpoena, can your records be subpoenaed? Yes, they can. And even of you can also be subject to a public records request. I mean, that's one of the things that I think strikes me the most, particularly with new board members in a city or a town, is to be told that anything that you make or you create or you receive as in your capacity as a ZBA member is a public record and has to be preserved as such. Now, the official record should be kept with Denise. I'm sure Denise, I know you all show up with your iPads or your laptops where everything has been digitally loaded. But, back in the good old days, you actually used to get an envelope that was either you came in and you picked up, or it was waiting for you on the table as you came in at 5:55 p.m. and you ripped it open and, okay, this is what we're doing tonight. And you'd go through and maybe you'd scribble notes on it. Maybe you picked it up in advance over the course of the weekend and you did some reading ahead of time so that you'd know what a particular report had to say, so you could ask some questions at the hearing. All of that is a public record, and technically even what you jot down in your notes would be a public record. But if you keep them to yourself, they are not public. They are personal to you. So, if you're making notes at a margin of a document where you want to remember, ask their engineer this question or ask an applicant to clarify this. Those are things that are just personal to you, not necessarily part of the public record. But as long as Denise has the official copy, you don't have to worry about what you scribble on or what notes you take. And every single day, there is a person sitting up in the select board's office whose one of their primary responsibilities is to monitor public records requests. And when they get a public records request, they have to immediately identify who might have records responsive to this. So if something comes in saying, I want any and all emails or communications with the building department and the zoning board regarding 12 Main Street, well, that records access officer is going to go straight to the building department, and go straight to Denise, but it could also come to any of the board members at any time and say, I need you to also search your emails and send me anything on 12 Main Street. Now, I get a lot of board members who say, I don't have a town email. And this kind of goes to Mr. Conroy's comment a moment ago. You don't have to email from a town of Plymouth email address for it to be a public record. You could be using your own business address. You could be using your own your personal email. If you're talking about town business, that's technically a public record. And now, unfortunately, the burden falls to you to search through your own personal emails and identify which ones might be relevant and forward those to the town. Same thing with your text messages. So one of the reasons Haley was saying, if you have a Town of Plymouth email account, makes it so much easier to keep all of those things separate, because then you don't have to search through your own records personally. You can instead rely upon the town's IT department to do the search and lift all of those emails or text messages off the server if they're keeping them. Subpoenas typically only come in the context of litigation, not always, but typically. And the subpoena can basically request all the same records that could come through a public records request, and perhaps even something more. So I think the only distinction there is whether or not we've been sued or there's litigation going on and somehow someone thinks that the town might have some information relevant. But I think I would be more concerned about the fact that any given day, we could receive a public records request, and we only have 10 business days to respond to that. So be cognizant of that with records that you're either receiving or creating and sending.
And just on the timeline of that, right, it becomes a public record as soon as it's created. So you could send an email, you could be up during a meeting, sending an email, maybe a member of the audience notices, and then right after the meeting, they could submit a request for that email that you're sending. There's also no statute of limitations on a public records request, so they can go back however far they want. Whether they're going to find stuff that's responsive is nebulous. You know, there's also the records retention schedule where towns are required to retain certain records for a certain amount of time. Like minutes are in perpetuity, so we've seeing a lot of requests recently trying to test boards, and they'll submit a request for all the meeting minutes and all the executive session minutes from like 1978. And so then we have to go through and make sure that those records are being kept somewhere and that all the executive session minutes were done properly and properly approved. Which also another practice tip, make sure that you are regularly approving your minutes. Meeting minutes need to be, for open session, need to be approved within the next 3 meetings, excuse me. And then for executive sessions, they say they need to be reviewed periodically, and generally that's considered around every 6 months. So you need to be approving looking at executive session minutes in 2 steps. One is you need to approve them as to accuracy. So you need to review them and make sure that they're an accurate record. And then the second is you also need to determine whether the purpose of that executive session is ongoing. So whether that, whatever you're meeting about still needs to be kept private, or whether you can release the content to the public. As Carolyn was saying, or Mr. Lear, I don't know if you had other questions. It looked like you maybe had a follow-up.
No, and the only reason I posed that question is I wanted the 2 new members to realize, because we've been through depositions, the rest of us, and Ed's right, you don't email or send or text, you know?
Yeah, the other thing, just on the litigation topic, is often public records requests will precede litigation because it's a good way for them to find out before going through the cost and expense of hiring a lawyer, or if it is a lawyer, of like going through all of that to start the litigation, filing a complaint, serving subpoenas, serving requests for production. They can just submit a records request, pay a pretty nominal fee, and get everything that they were looking for before litigation even starts. So that's something to also be cognizant of. There are exemptions to a public record, so you don't just get to ask for what you want as a free-for-all. So as Carolyn was indicating, notes that are personal to you, so long as they are not shared with other board members, those are exempt. Information which would result in an unwarranted invasion of personal privacy, that's exemption C. That's a pretty common exemption. And then obviously attorney-client communications, giving legal advice, that would be considered under attorney-client privilege. That is exempt, but generally always be cautious. It's going to be a public record. And as Mr. Conroy was saying, you can always just pick up the phone. Okay, so we're getting a little bit into retention. If you're not sure if a record is public, again, err on the side of caution, or you can check with your records access officer. They're the person who is in charge of monitoring all of the public records requests. They should be pretty informed on what is and what's not a public record. And then if a records request comes directly to the board, make sure that it's going through the records access officer before you send anything that is responsive. So if you as the chair get an email from a member of the public being like, I want these records, before you just forward whatever they're asking for, make sure it goes through the town's records access officer to make sure that none of those records are confidential or exempt. To that end, you're required to keep all email. Yeah.
One thing the board should be, like, I'll get emails from other attorneys wanting to talk about a case, never respond to anyone that asks for that. If something strange comes up where, I've been contacted by, town, citizens, I just forward everything to Denise. So never engage, an individual that's a town meeting person or a town citizen or attorney, never engage.
Yep. That's a good point. To that end, you're required to keep all the documents, emails, texts, except transitory documents. So transitory documents are anything that's kind of involving scheduling, procedural matters. You only need to retain one official copy of distributed materials. So that's going to be what Denise has. Otherwise, you need to fill out a form to request permission to destroy any documents. But again, if you have any questions, you can always ask the records access officer. All right, we've pretty much covered all of this. Use the formal tone when you're conducting public business. Avoid providing personal information, anything that you don't want out there, like your private phone number, medical information, etc. Avoid putting that in a public record. And again, phone calls always work. And that brings us to the last of the sunshine laws. That's the conflict of interest law. Anyone performing services for the town holding a municipal position, whether paid or unpaid, is considered a municipal employee. So public body members, ZBA members under the conflict of interest law are considered a municipal employees. So when you become a board member, you need to be provided with a summary of the conflict of interest law within 30 days of being elected or appointed, and then annually thereafter. So you need to recertify every year, and you need to acknowledge in writing that you did receive that. There's been a recent development on participation as an abutter for ZBA members. So if you are a ZBA member, if you as a ZBA member owns an abutting or nearby property to an application that is before you, the State Ethics Commission states that you cannot participate by vote, discussion, delegation, recommendation, or general advice. So really you have to recuse yourself from the matter. You can participate as a member of the public. So if you do have concerns about your neighbor doing something on their property, you can participate as a member of the public and bring those concerns to the board. As a practical matter, you kind of need to balance what protecting your interest as a neighbor, as a citizen, and what would be considered proper when you may have undue influence over your fellow board members. So it's something that you need to be cognizant of and just keeping in mind if this comes up.
Yeah, and who's supposed to interpret nearby property? I mean, if on let's say my street where I live, let's say somebody 6 houses up the street.
If you are someone who's entitled to notice from that public hearing, so you're either a direct abutter or
300 feet.
across the street or within 300 feet.
No, I'm not that. Let's say I'm out of that.
If you're outside of that circle, then technically you do not have to recuse yourself.
Okay.
You could still choose to recuse yourself by saying, look, this is very close to my property and
Or I don't like this guy.
or, approval or denial of whatever the project is might have an impact on the value of my property, be it positive or negative.
Okay.
You could choose to recuse yourself. But if you are someone who's entitled to notice of a public hearing, you must recuse yourself.
So we kind of remember the 300-foot rule.
Yes, yeah. If you've gotten a notice in the mail, and you say, well, gee, this is my own board's here, then you should absolutely recuse yourself. And when in doubt, reach out to general counsel and just, put an email or phone call just to say, I'm not sure what I'm supposed to do. To make sure you don't want to find out the hard way.
Right, because the State Ethics Commission has pretty substantial enforcement authority, so they can impose a civil penalty up to $10,000 if they find a violation, $25,000 in bribery cases. They can order you to repay any economic advantage that you gained by making some kind of improper, ethically improper decision. And these can also be prosecuted criminally. So as Carolyn said, if you do have any comments or concerns, you can always bring it up to your counsel. The Ethics Commission also has a free
Attorney of the day.
attorney of the day. Yeah. So they have somebody on call every single day and they can answer your questions as well if you do have concerns. So other types of conflict of interest restrictions, when you're on the job, obviously you can't take bribes. It can also include gifts and gratuities. You can't misuse your position, self-dealing, nepotism, can't make false claims. You also want to avoid the appearance of a conflict and the mishandling of confidential information after hours. So if second job conflicting with duties, so if you are a construction worker, developer, etc., and you need to have your application before a board, before the ZBA, obviously that would be a conflict. And then after you're leaving, you leave. So even after you're no longer a board member, there's certain things that have a forever ban, so certain things that you can never do. And then there's certain things that have a 1-year cooling off period, so you have to take a break for a year and then come back. And then there's also certain restrictions for your partners and family members. But that's just a broad overview. Any other questions for me or Carolyn? What time?
Questions?
Remind people of what's a friendly 40B or LID, because I'm presuming it goes through all the same processes, but tell us a little bit about a friendly.
The lip reading? The lip.
So a friendly 40B would be a 40B that is sort of affordable housing project that first starts with the select board under what they call the local initiative program, where a developer will go to the select board and ask the select board to sign on to their application to their subsidizing agency. And the idea is that an applicant hopes that if they get the support of the select board behind a project, that there might be less opposition to the project by the time it reaches the zoning board of appeals. So the select board will often, in exchange for their signature on the application to the state, the select board will often try to negotiate some mitigation in advance. Might be something related to, like a traffic improvement, or maybe a contribution towards a planned capital improvement project for upgrading the water supply infrastructure or sewer infrastructure in the area. Things like that are the types of things that could be included in this agreement. And assuming the select board and the applicant see eye to eye on these things, the select board will endorse the local initiative program application. It will go off to the state, and the state will decide whether or not the applicant is entitled to what they call a project eligibility letter. which is essentially the developer's green light to go ahead and file a comprehensive permit with this board. And even though the select board and the applicant may negotiate some mitigation in advance, there's no requirement that they do that. It could be a particular site that the town is just particularly supportive of there being, they think it's appropriate for housing. It may be that they think the size, the number, the style is all in keeping with the surrounding neighborhoods. So the select board could simply endorse the application just because they like the project. But that's essentially the only difference. It's still got to go up to the state and get approval in order for them to even be able to apply to the zoning board, and you're going to go through the same hearing process as you would any other, an unfriendly, shall we say, 40B, and render a decision in the same manner.
But is
Any
it
other
kind of a way to
questions?
put a little pressure on the zoning board?
Through a lip, you know, for doing
Through a
it as a friendly
friendly-
40B?
Friendly, seems
Well,
it to me.
I mean, every time I have negotiated one of these agreements between a developer and the select board, we are always very careful to say that, you know, say in exchange for X, Y, and Z, the select board will support this application. But we always add language to make it clear that this does not usurp the authority of the zoning board, that ultimately you are the ones that have to make this decision. But I do appreciate it can sometimes put the zoning board in a difficult position, particularly if, you know, if the applicant has agreed to provide substantial mitigation, and it is mitigation that this board feels, gosh, we know that the town really needs help with that particular project, you might feel that you're being somewhat pressured to approve it. But there's nothing in that agreement that ever could say that the select board is guaranteeing that the zoning board would approve the project.
Any other questions or, no?
Can I make a comment?
Yeah.
There, on our website, there is a contact board button that people can directly email you. I don't see that at all. So it could be that all of you are getting email. They can't do it individually, but the whole board would receive something from.
Yeah, I've gotten
a
them
res-
before. Yep.
Okay.
Any other questions? Well, I want to thank both Carolyn and Haley for coming down and going through everything. We appreciate it. Where we had a couple new members, I felt it was needed. The only other order of business we have is the minutes. I'm sure you've all read them. The persons that be voting on this would be myself, Peter, Ed, and David, and it was meeting minutes of March 16th. Any comments or? No? Okay, well,
Actually, it's not Peter because that was the Pulte case and you weren't, oh, you were sitting. I'm sorry.
yeah, I read who was there. Okay. So that's what I'm using. Okay, so, well. Okay, second. Ed seconded. All in favor? Okay, I'm waiting on a motion to adjourn.
Move to adjourn.
And everybody seconds. Thank you. That concludes the July 20th zoning board meeting.